Okay, let's get started. My name is Jim McCloskey, and today we're going to be doing the 4-hour mandatory for the Real Estate Commission for 2015. And you should have your material in front of you, and we will be going through this. And please ask questions. Please slow me down if I'm going too fast. Let's make sure you grasp this, because there's a lot of new material, especially when it comes to homeowners associations and managing property management, etc. So let's start with right at the table of contents, and of course we have compliance issues, general practice issues, new regulations, of course, resources, division news, etc. And the next disc on the disc 3 talks about recommending that the brokers take this from January to June. And of course I'm kind of preaching to the choir here today, because you guys are taking it very early in the year. And you should also take a separate contracts class. This is not a contracts class. There are some mention about some of the changes in contracts, but nonetheless, this is not considered a contracts class. So if you need contracts, please take that separately. Give us a call. We'll be able to help you with that as you're going through the course or as you're going through this year. Let's talk about some compliance issues concerning errors and omissions insurance and listings and commissions position statements, property management, attorney drafted forms, and counter proposals to a counter proposal. Talking about Rule E21 violations and how to terminate a buyer-seller listing contract. Let's look at errors and omissions insurance here. It says errors and omissions is required for all active licensees. That's no mystery. The Commission audits all licensees and will place their license on inactive status for failure to maintain an active policy. Inactive status starts and ends of coverage and continues until proof of coverage is sent to the Commission. And inactive brokers may not engage in any licensed brokerage activities. Independent brokers only need individual coverage. There was a time a few years ago where independent brokers needed a separate policy for their company also. Not anymore. Independent brokers just need one policy, which is nice. And broker associates may have individual or group coverage depending upon the firm that they work for. Some larger companies get a special break or subsidize some of it for the brokers, and that's fine. On slide 6, we have errors and omissions insurance is a claims-made policy. The policy order must have coverage at the time of the event and at the time of the claim. Now, if you look at slide 7 here, it talks about tail coverage. And this is the problem a lot of brokers have. They will have errors and omissions insurance, then they'll retire or they'll go on vacation, put their license on inactive status, and cancel their errors and omissions insurance. If that happens, all of your coverage you had before that errors and omissions is gone. So let's say you have a year from now, you decide to go on inactive status, and a year from now you get sued for something that happened 3 years ago, and all of a sudden you don't have any errors and omissions insurance. Even though you were covered then, you aren't covered now. You have to keep that insurance in place, and it's very important that you remember this. And so many brokers have made that mistake of canceling their insurance because they're on inactive status or they retired. I had the biggest appraisal firm in Colorado for 12 years, and when I retired from appraising, I called up the errors and omissions company and asked them how much a tail policy would cover me from now on for forever, because I had like 300,000 appraisals wandering around out there. I had to pay $14,000 for additional coverage just to cover. I liked sleeping at night. I didn't like writing out that $14,000 check, and as it turned out, I didn't have any claims. Like, what is the statute of limitations in Colorado? It's 2 years from discovery, 3 years if there's been fraud. I was talking to one of the underwriters over at Williams, errors and omissions underwriting here a few years back, and she was saying they're getting more and more claims from people from things that happened 8, 9, 10 years ago. Usually after 7 years, it's pushed, is set aside, is what it's called, but not necessarily. People are selling their homes and they've been in there for 10 years, whatever, and they go to sell it, and all of a sudden they realize that the home that's only 1,500 square feet, their broker told them it was 1,800 square feet or 2,000 square feet. Now they go to sell it, they find out it's 500 square foot less. And all of a sudden they do have a liability issue against that broker. So again, the point is, make sure you keep your coverage in place. Even if you retire, even if you put it on ice for a while, make sure that you're covered. And again, these tail policies, this is on slides 7, 8, and 9, are a wonderful rule to use, and that's what the verbiage is when you're talking to your errors and omissions companies. Talk about these tail policies. Look at slide 11. Talks about the position statement has been revised and should be reviewed. And this again is slide 11. Where, coming soon, the position statement has been revised and should be reviewed. Is it in the best interest of the seller or the broker? Does the seller understand limiting exposure? What is the purpose for a double-ended transaction? Should be the seller's decision, not a sales tool, and must be in writing prior to marketing. Let's talk about some of these. First of all, is the best interest of the seller or the broker? I want to do both ends of the deals. So do you guys. You want to have the sales end, the listing end, and the sales end whenever you can. Is that to the best interest of the seller to do that? And that's when the rubber meets the road. Who is taking advantage of who? And we've got to make sure that we are correctly explaining to our seller how we're working with both ends of the deal and why we're doing it. I think it's frustrating sometimes when I see when brokers sit there and say, yeah, I'll list your home for 6%, and if I bring in the buyer, I'll drop my commission down to 3% or 4% because I'm getting that in. I'll make up the difference when I sell you a home. And is that to the seller's advantage doing it that way? And it definitely is. So again, you want to look for the other people's benefit. And a double-ended transaction. And it should be the seller's decision. And why do we want double-ended transactions? Give me a break. You know, we're all involved in this business for the money, let's face it. It's kind of interesting. I trading people get into business, and some new brokers will say, I just want to help people. I just want to help people get into houses. I'll tell you what, this is a business. You're in this business to make money. I'm in this business to make money. So again, you're not in this business for your health, although many times it does affect it. So remember that. Let's go again to slide number 12. Property management, areas of continued concern, proper handling of funds of others by the brokers. All money received in connection with property management agreements, rent or lease contracts, or other purposes associated with the property, owner or tenant must be placed in an escrow account. Rent and other deposits must be made within 5 days of the receipt. Within 5 days of the receipt. And a broker is responsible for the proper accounting of the escrow accounts. And even if you have your escrow accounts held by a property management company, in some cases you'll have some of them held, you're still responsible for them. And monthly accounting must show the receipt of money, the distribution of all money, and any remaining balances.
That's the journal, right?
That's yes, this is the general monthly accounting. And this again, this is all Colorado specific. Is that what you were asking?
It's the journal that you were talking about.
Oh, the journal. Okay, I thought you meant the general. Yeah, it's the journal. And where would you find a complete listing of everything in chronological order? In the journal. Then, of course, we'll have our separate ledger cards for every one of our clients also. So the ledger cards and the journal cards. That's a balancing. That's the balancing equation. Let's go to slide 13 and put a couple stars by this. At the end of this class, we're going to have a wham-bam 10-question test. Not too heavy. And you should zip through it pretty well, but put a couple stars by this slide number 13. Where it says property management, it says areas of concern. Proper handling of funds of others by brokers contains security deposits received by a broker, property manager cannot be transferred to the owner unless you're authorized in the signed lease, or the broker notifies the tenant in writing with the name and current mailing address of owner holding the deposit. This should also include the requirements to get the security deposit back. Notifications should be sent by first-class mail, and security deposits must be returned within 1 month unless the lease stipulates a later time frame, which may not be more than 60 days. Let's go down, break these down. And again, the security deposit. We're talking about property management now. We're not talking about the earnest money deposit in the sale, but the security deposit received by a broker property manager cannot be transferred to the owner unless it is in writing that that's the case. And of course, every seller thinks that they own that deposit. Well, they don't own it. It belongs to the tenant. That's why it's so dangerous to give it to the seller. And the broker notifies the tenant in writing with the name of the current mailing address or the owner holding the deposit. This should also include the requirements to get the security deposit back. And again, notifying the buyer that the seller's holding the deposit. Most buyers or most tenants don't understand the importance that the seller should not be involved in actually holding that deposit. Should be our responsibility. And notification should be sent by first-class mail that the seller is holding that deposit, if you should decide that. And of course, security deposits must be returned within 1 month or 60 days. It's not 1 month or 2 months. It's not 30 days or 60 days. It's 1 month or 60 days with an extension. And it has to be returned to the tenant at that point. Let's go to slide 14 here. And it talks about the areas of continued concern. Proper handling of funds of others by the broker continued. Wrongful withholding of a security deposit or part of a security deposit by the owner or property manager may result in treble damages and attorney fees being awarded to the tenant. But there's specifics about that. Talk about that in just a minute here. Tenant cannot be charged for normal wear and tear items. Normal wear and tear means deterioration which occurs based upon the use for which the rental unit is intended, without negligence, carelessness, accident, or abuse of the premise or equipment by the tenant or members of the household, or their relatives, or their guests. Now, let's talk about this for a little bit here. This security deposit, and of course most landlords think that that's theirs, and it isn't theirs. It belongs to the tenant. And we cannot have a requirement in our leases where the tenant has to clean the carpet, that he has to clean the oven. You don't do that because that's normal wear and tear. And if you put that in your leases, and virtually every property manager has that in their leases, and that is actually for an illegal purpose. It could conceivably cancel the contract, cancel the lease. And again, that's normal wear and tear, and you cannot retain a deposit for normal wear and tear. And how many people know that? Virtually nobody. You know, and it's in virtually every lease that you have to have your carpet cleaned, and that
Clean
thing
many carpets.
has to be the same condition as when you moved in. Oh, no, no, no. No, there's normal wear and tear is accepted. So,
But can you call it normal wear and tear on a, let's say, an oven?
what's normal?
And I'm speaking of an oven that, you know, you go in through the walkthrough with the tenant that's ready to leave, and you look at that oven, and that oven is just horrible. And
What if that oven is horrible?
there-
What if there's holes in the wall, there's holes in the carpet? That's not normal wear and tear.
No.
That's not normal wear and tear. If that oven has just been brutalized,
Well, I'm talking about that it's just, it's still an operating function, but it's just so filthy inside, and they should have just cleaned it, that's all. We're just talking cleaning of the oven.
and that's just it. What are we talking about? We can go down piece by piece by piece, but
Right.
and the landlord just has to be aware that normal wear and tear is a part of running that unit.
Right, that's
And
expected.
they've got to understand that they cannot retain part of the security deposit.
Right, part of it, right.
But, so I give you your,
So can you charge for that?
if the oven is disgusting or whatever, sure.
Yeah, just for that work that you have to get somebody else to do that cleaning up of that.
And it's case by case, of course, but,
Right.
you know, use common sense. The holes in the wall and stuff, you can charge them for that.
Right.
Holes in the carpet, things like that, that's not normal wear and tear.
Right.
Holes in the ceilings, see that? So all of these things that come together, and you have to be able to break it down and say, this is what the costs were.
Right.
So, during that 1 month or 60-day period, I send you back half of your deposit. But I don't tell you why I retain the other half. I have to give it all back to you. All back to you. I have to break it down why I kept it. If that 1 month or 60 days go by and I have not returned any of it to you, I could be reliable for that deposit plus treble damages, 3 times the amount. So again,
And you have to have an extension for that added 30 days to the 60?
yes, the question was, do you have to have an extension for that additional, you can say 30 days or month, what do you want to call it?
Right, yeah.
1 month or 60 days, and never exceeding 60 days for that deposit. So, and let's go to, put a star by that number 16 there, with 13, but it's number 16. Put a star by that also. Where are we at here? We got number 13, we got 2 stars by that one. I told you number 14. Number 15, we got property management. Let's look at slide 15 here, where it says areas of continued concern. Proper handling of funds of others by brokers continued. A written statement or accounting must be sent to the tenant if any portion of the security deposit is retained, what we were just talking about. The statement must include a list of the specific reasons for charges and the remaining balance of the deposit. It should be sent by first-class mail to the last known address within the required time frame. 1 month or 60 days or is listed in the lease. Unfortunately, a lot of times the last known address is the place they were renting from you. But they should have a change of address. And property management and areas of continued concern. We have proper disclosure, and again, if you don't break down why you kept a portion of that deposit, you have to give it all back. Let's go to number 16 here, proper disclosure of brokerage relationships. Both leasing brokers and property managers are required to disclose brokerage relationships in writing prior to entering in any activity that requires a broker's license. Commission-approved form brokerage disclosure to the tenant should be used for this disclosure. And a lot of brokers don't understand that this is a required form that has to be done. How you're working with your clientele. Number 17. Like I say, put a star by that number 16 there. And it's the broker's disclosure to tenant form. Go to number 17. Attorneys drafted forms. Brokers ultimately responsible for content of even the attorney's forms. We're responsible for those. And the broker must be able to identify the attorney that drafted the form if asked by an investigator. Then you have practical situations, a counter proposal to a counter proposal. There's some confusion about this also. So I have I counter the counter. Does that mean that all of a sudden I have to do a new contract? No, we don't have to. You can have 4 or 5 counters. But if you get getting 2 or more counters on a property, you really should redo that contract once you get everything in place. So you're not sitting there and having all these counters all over the place. It just makes it move so much cleaner. And that's just kind of common sense issues. Let's go to number 19. Practical solutions. Counter proposal to a counter proposal. And it says, a counter proposal constitutes a rejection and termination of the original offer. The first counter proposal may not be acceptable to a buyer. And the buyer can then counter that counter proposal. And a counter offer to a counter proposal is a rejection of the previous counter proposal. However, the terms of the original offer still apply. Even though that original offer is terminated, we've got these counters that are added to it. In practical situations, counter proposal to a counter proposal. Go to slide 20 there. Each counter proposal may be further countered until all parties reach an acceptable agreement. All parties should be clear on what the final agreement contains. And the best practice, it may be better to write a new offer with all the terms and conditions agreed to during the negotiations. And that does work so much cleaner. What are you looking at? You're looking at just a few minutes to get that cleaned up. Make everything smooth, go through much, much easier. Let's go to slide number 21 here, or 25, excuse me. Actually, let's go. I'm a little ahead of myself here. Let's go to slide 21. Slide 21. Practical situations. Counter proposal to counter proposal. When a complaint is opened against a licensee, the division will alert that licensee via a notification letter. And Commission Rule E21 requires the licensee to submit a written response within the time allotted as determined by the division. And the written response must include the following. This is slide 22. A specific answer to all allegations made in the complaint, answers to any additional questions in the notification letter, and a complete transaction file as well as any additional documents request and the notification letter. Now, nothing to get paranoid about here. First of all, just because you've got a complaint from someone doesn't mean you necessarily did anything wrong whatsoever. You're going to answer their complaint, they're going to answer your answer, you're going to answer their answer, then they're going to decide what they're going to do at that point. And it may be nothing. And of course, the lowest form of disciplinary action is a letter of admonition, essentially just a slap on the wrist.
Who is the division?
Pardon me?
The division that decides this.
The Real Estate Commission.
Okay.
And it may go all the way to an administrative law judge, but very seldom does it go that far. Usually work it out ahead of time. You get it squared away. And continuing with number 20, slide number 22 there, it says, when a complaint, and look at that Commission Rule E21 continued. Let's go to slide 23. Do you have did you grab here we go. We're on slide 23 right now. And slide 23, it says Commission Rule E21. Response to complaint. When a complaint is opened against, you'll get the letter in writing, you'll answer it in writing. And go to slide 23, where Commission Rule E20 requires license to submit the written response. And then let's go to slide 24, where it says a broker received a request for response to a complaint from the Commission. Despite multiple extensions being granted, the licensee failed to provide a complete transaction file with their response. After completing an investigation, the Commission found insufficient evidence of a license law violations relating to the allegations of the complaint. So the guy didn't do anything wrong. Did the broker have any further liability to the Commission? Well, yeah, they answered everything late. So they do have a liability issue. They would have gotten nothing against them if they would have just provided all the documentation. And number two, would it matter if the broker's attorney had failed to respond? And again, we are responsible for our attorneys also getting those in. And how to terminate a listing contract. Let's look at slide 25. Practical situations. It says a seller has contacted ABC Realty and verbally told the listing broker the seller is terminating the marketing of the property. The listing broker agrees to send the seller a termination notice. The listing broker sends the notice stating the company will discontinue all marketing of the property immediately. The company removes the sign and changes the property status in the MLS to withdrawn. A week later, a new listing brokerage, when entering the listing in MLS, finds the property still showing as listed with ABC Realty. Has the listing contract been terminated? No, it hasn't. They just took it off the market. It hasn't been terminated. And how do we terminate a listing contract? We have to have a termination letter, is how we do it. Go to 26. Listing contracts between the brokerage firm and buyer or seller should always be terminated in writing. Needless to say, if the full contract is not being terminated, clients must inform of what duties are being terminated. And a discussion of the holdover period in the contract should be held at the time of termination. And the holdover period is the time, well, if you have a listing on a property and you let the seller know in writing that you showed the people that property, you let them know in writing that it was showed, and your listing comes to an end and they either take it off the market or list with another broker, you then have a holdover period with someone you showed that property to comes into that house. You're able to bring them into that house and get your full commission, both ends of the deal, even if they list with another broker, until that new broker does something that merits a commission. And that's how the law reads. And how to terminate a listing contract, again, with a termination notice. And now, and slide 27. Put a slide by this. Termination may occur by amending the contract expiration date or by adding language in an amendment stating the date of termination of the subject property, and it must be in writing. Put a star by that. It has to be in writing. The brokerage firm's office policy should describe how listing contracts are to be terminated. And then we have on 28 general practice issues. Rule E8 and CP45 in advertising. The brokerage commissions inserted into the contract to buy and sell. The supervision requirements for employing brokers. Fair housing issues. Rule E8 when it comes to advertising. Let's look at this. This is slide 29. It says revised in 2014, which after? Pencil? You got it. Okay. Revised in 2014, the new additions to the E8 rules are designed to keep licensees compliant when advertising online via any type of website or social media services. And the licensee is responsible for maintaining compliance on and accuracy for all online content, even if using a third-party provider. Isn't that something? So we're still responsible even if someone is doing it for us, and most of them are doing it for us. And incorporated C19 name rules into the new advertising rule. And CP45 is adopted to define the terms. Let's go to E8, the advertising content, slide 30. Definitions under the rule and position statements. Advertising. Any promotion, solicitation, or representation of services requiring a real estate license. Part of the position statement. And names. No person shall be licensed under more than one name and shall not conduct or promote business except under the name under which such person or the brokerage is licensed. Common sense stuff. And teams. Brokers that form teams shall not advertise in a manner that misleads the public as the identity of the brokerage firm under which they are licensed. Acceptable team name usage is defined in this rule. We can't present ourselves as someone outside of the organization itself. And that's what their concern is. Let's go to slide 31. In advertising, continued. Definitions under the rule and position statement. A trademark. A trademark is like Century 21, Remax, those are trademarks. Any logo, service mark, or other identifying mark used in conjunction with a brokerage firm's legal name, and a trade name, the name under which a brokerage firm does business under the brokerage firm's legal name. And then whatever advertising. Slide 32 talks about the brokerage responsibilities for information advertised. This is kind of good they're doing this, because it used to be online advertising. There was just like no rules on it because nobody really knew what to do about it. I remember when we first started doing online advertising, when online first started. And the Real Estate Commission had some confusion. They said, well, just make sure everything's, you're not exaggerating or lying. Now they're trying to get some real definitive ideas about this, which is good. It's overdue, and they're finally doing it, which is good. Let's read this, starting in box 31 here. And again, the trademarks. Go to number 32. The broker's responsibilities for information advertised. The brokers must ensure the information advertised is accurate and in compliance with the copyright laws. And the broker must also ensure advertising that recaps sales activity over a period of time in a specific subdivision or geological area, cites the source of the data, and includes a disclaimer that all reported sales were not necessarily listed or sold by the broker advertising the sales activity.
Quick question, Jim.
Yeah.
Is that why I get flyers from my condo? Not flyers, but postcards from my condo. I sold 3 units in this condo.
Oh, you better believe it. That's a good question. You get advertising people. I'm your man. I'm the broker for this subdivision. And if you do that, you should say, I've sold 3, I've sold 4, I've sold 5, whatever. Because by just insinuating that you're the broker for that area, it could be construed that you're saying you sold everything. So that could be a problem. That's a very good point, TJ, you bet. And, where are we here? Number 33, the advertising continued. On that slide 33, broker must ensure every viewable page includes the license name of the broker and the brokerage. And the broker is responsible to ensure expired listings are removed within 3 business days. Within 3 business days. And who usually is upset about that? And that's usually the people buying the property and their broker. And the other one's going to call up and say, hey, it's been 4 days. Why the heck that's not off the market or out of the MLS? So make sure you do that. Be diligent about that. Continuing, brokers using a third party to maintain the website are responsible for all content on the website and must ensure all information is accurate. And they must request expired listings be removed from the website within 3 business days. Again, expired listings. And number 24, and the listings continue to slide 34. If the type of social media the licensee is using does not allow for appropriate disclosure of licensees and brokerage firm names, the licensee may place a link inside the communication to link to the required information. The link must display the required information within 1 click. Let's go to 35 here. Advertising continued.
How do they get away with all these websites that have all these houses that are gone? I mean,
These websites,
months, it's like none of the houses are accurate.
you mean the ones that they're off the market now? They
Yeah.
haven't taken them off? Is that the question? How do you get away? Well, that's why we're having this, to clarify. You got 3 days to get them out of there. And nobody's so busy that that's a problem. You should always
Obviously
be able
it
to
is
do that.
because there's all these houses on there that are not available.
Well, it's not a problem. That's why we're having this. It shouldn't be a problem. It takes 2 minutes literally to go in there and change that. So, that's a good thing to do. I mean, that's not a problem. Go in there, you have the deal closed. What the heck should be a little celebration? Go in there and take it out of there. So, let's continue. Then on 35 we have the emails. The emails, the IMs, the news groups, the blogs, the discussion lists. When communicating through these systems for proposal of real estate related activity, the licensee's and brokerage firm name must appear in the communication. And if you don't have your name in there right, that is considered a blind ad. And once the disclosure has been made to a specific client or customer, the licensee is not required to continue to make the disclosure in future communications to this party. Common sense stuff.
In other
And
words, you don't have to say your name twice.
Pardon me? It's,
What would that second sentence mean?
what does that second sentence mean? Let's read it again. Once the disclosure has been made to a specific client or customer, the licensee is not required to continue to make the disclosure in future communications.
In other words, you don't have to tell them your brokerage name and your.
Right, and you put it in writing one time,
Okay,
and that should take care of it.
too simple.
Yeah, almost, yeah. Let's go to slide 36 here, where it talks about banner advertisement. Broker must ensure the licensees and the brokerage firm's names are prominently displayed in all banner ads. That's just common sense. And if there is not sufficient space for the required disclosure, there must be a one-click link to the required information in the commissions and then on top of page, actually in slide 37, talks about that ad up there. Does this ad comply? Nowhere near. It doesn't have the name of the company, it doesn't have the name of the broker working it, it doesn't have phone numbers. This is a blind ad, and it's totally unacceptable. Put a star by this slide 38 there, 38. Practical situations. A buyer's broker has entered into buying a listing contract, into a buyer listing contract in which the buyer is obligated to pay the brokerage fee. The buyer is obligated to pay it. The broker shows the buyer a home with a co-op fee of 2% less than what was agreed to in the buyer's listing contract. The buyer writes an offer, and in additional provisions, the buyer's agent requests the seller pay the 2% difference. Is it acceptable for the buyer's agent to insert this commission request? What if let's talk about it. Let's see. What if the buyer listing contract stated the buyer would not pay? And it is acceptable for the buyer's agent to insert the commission request? You can always request it. And this is just something, remember, in a buyer's agency agreement, the buyer is ultimately responsible. And is the buyer being harmed by this? So again, you can request it. And what if the buyer's listing contract stated the buyer would not pay? Well, then you don't have to worry about it. In a transaction broker arrangement, of course, the buyer is not obligated to pay you if you don't get paid for your commission. And the buyer agency is one way of tying up the buyer so that no matter what happens, you're going to get paid. And it's not an issue. The listing broker is going to pay you. Very, very seldom is that ever an issue. I think I've heard of one or two cases where people have called me up and asked me about it. Some that's pretty easily rectified, where working with the seller on that.
So this buyer listing contract, it's pretty unusual.
What's the buyer agency? It's the buyer agency. We have a buyer agency where if I have a listing contract, no matter who sells that property, I get paid even if the seller sells it himself, an exclusive right to sell listing contract. The antithesis to that is working with the buyer, where no matter who sells him a property, I get paid. And people like working as buyer's agents a lot of times. It's up to you how you want to work with them. Some people are only buyer's agents. They don't take any listings at all. You have breakfast with them, find out what they want, get a listing, buyer's agency, take somebody else out to lunch, etc., make a very good living doing that. So again, but the buyer is ultimately responsible. Who pays it? The commission? The seller does. But the buyer goes into a new home subdivision, doesn't say they're working with you, and buys a home, you could go after them for that. That can happen. Let's go to number 39 here. The rule F2 has been interpreted by the commission to preclude the introduction of commission info into the contract. A broker's commission may be introduced into a contract under limited circumstances when the introduction is in the buyer's best interest. And commission in the contract to buy and sell continues. Slide number 40. If in the buyer's agency contract, the buyer's checkbox 731, buyer is obligated to pay, buyer shall be obligated to pay the broker's firm's fee as described in 711 as a success fee, and the commission is higher in the listing than the amount offered in the listing company on a property. At the buyer's request, the buyer's agent may add language to additional provisions in the contract to buy and sell, requesting the seller pay the difference. You can always request and see what happens from there. Let's go to slide 41, where it tells commissions on the contract to buy and sell continue. If the box in 733, listing brokerage firms or seller may pay, buyer is not obligated to pay, is checked, the buyer is not obligated to pay. Common sense. The broker would have to negotiate outside the contract to buy and sell with the listing broker for an increase in the co-op fee. And again, let's go to slide 42. Commissions in the contract to buy and sell continued. Caution should be exercised, and all brokers should consult with their employing broker before inserting this clause that we talked about. It is always recommended that variations in commission rates be discussed with the buyers before properties are shown or contracts written to avoid the situation above. And obviously this is something that's coming down on us right now, where these buyers are being forced to make up the difference in any commissions that are being paid. And let's slide 43, where we have supervising requirements for employing brokers and level of different supervision. The level of supervision required by employing brokers depends upon how experienced the employed broker associate is. Rule 31 applies to the brokerage associates with more than 2 years of experience. And this rule requires a reasonable level of supervision. Rule E32 applies to broker associates with less than 2 years experience. This rule requires a high level of supervision. And supervision requirements for the employing brokers. Slide 44, the rules are designed to ensure that employing brokers provide the supervision and assistance needed by the broker associates to protect the public and confirm compliance with all real estate commission rules and regulations. And supervision requirements for employing broker. Let's go to slide 45. The brokerage firm must have a written office policy describing the duties and responsibilities of broker associates employed by the broker. All employed broker associates, no matter the level of experience, must sign that they have received and read the office policy. The office policy must be available for inspection upon request by any authorized representative of the commission. And the supervision requirements for the employing broker. Rule E31, slide 46 here. Reasonable supervision requirements include review of all executed contracts in order to maintain assurance of competent preparation. And that's again review of all executed contracts. Review of all transaction files to ensure it contains all required documents. Having a list in your files about what's in that document helps a lot. And nothing in the rules shall prohibit an employing broker from designating supervisory authority or other experienced active brokers. And this delegation must be done in writing and signed by both brokers. And supervision requirements for employing brokers. Let's go to slide 47. Rule E32, a high level of supervision requirements for the employing broker includes all those listed in Rule 31 plus providing specific training in office policies and procedures, being reasonably available for consultation, providing assistance in preparing contacts, monitoring transactions from contract to closing, and reviewing documents in preparation for closing. Ensuring that the employing broker or an experienced broker attends closing or is available for assistance. And again, ensuring, but there is no requirement that a broker be at the closing. But they sure should be. And if you go to work for somebody, always ask them, will I have someone helping me with these closings? At least for your first half dozen, for sure. Let's get into fair housing in a minute. Why don't we go ahead and we'll take a 10-minute break and then we'll come back.
How many questions
Okay.
are going to be on the state test about fair housing? Quite a many, right?
How
Quite a
many
few.
questions on the state exam for your pre-licensing, you mean?
No, for fair housing. Quite a few, right?
For fair housing, for the pre-licensing on the state exam? Or this exam?
No.
On the
The
state
state
exam? Not that many. There aren't that many, and they're fairly easy questions because fair housing is so cut and dried
Mm-hmm.
to a point, even Colorado. So let's talk about fair housing, and fair housing is something, again, you should really take a class or two in fair housing every year because it changes. You know, the common law changes in court cases, and of course the state can change things too. So let's look at this 48, this disc for fair housing and federal protected classes. These are the federal protected classes. We have race, color, religion, national origin, familial status, gender, disability, and there's additional protected classes underneath Colorado, and a lot of people don't realize Colorado has the most number of protected classes. They have marital status, and notice marital status is not part of the national. We're one of the few that has marital status. I remember when I first moved out of my folks' house, you know, my house, I should say, they had singles-only apartments. You can't have singles-only apartments anymore because you can't have marital status. That's part of fair housing.
Didn't they have one in, anyway, it doesn't matter.
Singles only, they better not.
They used to.
Well, they used to, yeah, but see, this changed way back when. So again, a lot of people do things and not realizing that they're not supposed to do them.
But don't they allow for age?
No, age is not protected under fair housing.
Even when it comes to older people and older
No, when
developments?
it comes to older people, that falls under the familial status, where you can say no kids allowed. That's only for retirement communities. Because we're heading in that direction. So
Okay.
let's kind of mosey here. So marital status, I'm on slide 49. Marital status, transgender status or sexual orientation. Again, homosexuality is a protected class in Colorado. It's not protected in every state. And then we have creed and ancestry. Is there a difference between those two? I don't know. But if you think there is a difference, then don't discriminate against either one. It's the way to look at it, I guess. And then some unique parts we have in Denver County: military status, parenthood, persons over 40 years of age. You can't discriminate, is what they're saying. And and then for fair housing for Aspen, Boulder, and Crested Butte, political orientation, age is protected, and family responsibilities like domestic violence, child molesting, things like this, all could fall underneath additional penalties under fair housing. And then Telluride, political orientation, age, family responsibilities, again, military status, fair housing. Colorado Fair Housing Law, which includes the federal protected classes, applies to both residential and commercial properties. Let's back up. I just jumped ahead of myself. Let's stop with that fair housing underneath Telluride. Military status and right above that, military status. And so again, they're just breaking it down individually for these different communities here. But generally speaking, in all of Colorado, age is not a protected class, but it's individually protected in these different communities here. And Colorado, look at slide 51. Colorado Fair Housing Law, which includes the federal protected classes, applies to both residential and commercial properties. So it's residential and commercial properties. Federal Fair Housing Law applies only to residential, Colorado residential and commercial again. Refusing to show, rent, lease, sell, or transfer commercial property because a party is a member of a protected class is a violation of Colorado Fair Housing. And slide 52, practical situation. A husband is working with a commercial broker to help him find a restaurant location in Colorado. He is moving his family business here from Mexico City and asked the broker to help him find a property in an upscale Spanish-speaking area since his wife is not fluent in English. The restaurant will be like their current 3-star Mexico City restaurants and offer higher quality and priced Mexican food. May the broker respond to this request. And again, so what are we talking about? We're talking about steering as far as fair housing goes. You cannot steer people to or from an area because of anything to do with fair housing. In this case, it would be race or because they're a minority, and of course we can say that. Where I've run into this before is dealing with, and it could be anybody, but Vietnamese. I'm not singling out Vietnamese, but that's where I've had my experience in it, where they have told me that they want to be in the Vietnamese part of town. Well, that's cool, and I put it right in their contract that they requested that they be shown that part of town, and that's fine. And you make sure you document it. Wow, make sure you document it. And it's interesting. No, I always thought the Vietnamese part of town, of course, is over in Federal and Alameda in that area. But there's a huge Vietnamese population up on I-25 and actually I-25 and 120th, just west of there. Another big Vietnamese population I didn't even know about. So again, it's kind of interesting when you're working with different races and everything to know where these other places are for compatibility and everything.
Well, especially with a commercial, like in this statement.
Where he's trying to make sure that he has it's Spanish-speaking
Right.
restaurant, Spanish-speaking part of town. Yeah.
It's gonna bring your business, more business because of that type of culture.
Sure.
So it would just make sense.
You know, it really does, and that's the key word. It really is. What makes sense? You know, don't reinvent the wheel, and keep it simple. You know, really. And what should be the broker's next step? Again, just make sure you document. And number 53, rules for complying with the federal fair law when advertising. Do not state or imply any preference for or against members of a protected class. Describe surrounding neighborhoods in general terms only. Examples, close to Chinatown is not permissible. Do not use religious symbols. Slide 54 continues. Your advertising rules continued. Use models who reflect the population of your metropolitan area. Include the fair housing logo in statements and ads. Recommend it. Put that fair housing logo on your business cards. It's not required, but you really should have it on there. And keep records and receipts that reflect broad, non-discriminatory ad campaigns. And the key, advertise the property. Not who should advertise the property, not who should live in it. And that's one of the things that we have to be very much aware of. That we're advertising the property itself, not the surroundings around it. And then we go to slide 55, service animals. This is interesting here. Under the ADA, a service animal may only be a dog individually trained to do work or perform tasks for a person with a disability. But this will surprise you. There's an exception in some instances for miniature horses. Isn't that wild? Serving the visually impaired as a service animal. So only animals and only dogs and miniature horses. And generally, service animals must be permitted to accompany persons with disabilities in all areas where members of the public are allowed to go. And that's generally, not always, but generally. Let's continue. Slide 56. Assistance animals, federal fair housing definition. Assistance animals encompass service, companion, and emotional support animals. And assistance animals should not be viewed as a pet. An assistance animal may or may not be trained. The breed, size restrictions cannot be enforced against assistance animals. And an assistance animal may be any kind of animal, not just a dog. Isn't that something? And fair housing. Both state and federal law allow disabled tenants applicants to make requests for reasonable modification and accommodations at any time during the tenancy. Let's back up to these assistance animals also. Remember, if you have a no pet policy and someone comes in with an assistance animal, you have to allow them to rent that place. And you cannot charge them a pet deposit. So, and if someone calls up and says they want to modify their apartment in any way, maybe they have to make the doors wider for the wheelchair, drop the kitchen sinks or bathroom sinks, you have to allow them the opportunity to do that. But they have to pay for it. You can even have them put money into an escrow account to pay for it after they move out, if you want to. You kind of be foolish to, because once it's for the disabled availability, you're gonna have people lined up around the block. They're lined up around the block these days anyway. So, how about the next one? It is critical to understand how to deal with disability issues. Property managers should have a protocol in place for handling reasonable accommodations and reasonable modification requests, and to get assistance with developing a protocol and or responding to such requests, and consult with an attorney if you need to, if you have any doubts. And let's look at slide 58, practical situations. A broker places the following ad for a property she is selling. Perfect home for a large religious family, close to 5 churches. Enjoy this mostly upper middle class neighborhood. This could also make the perfect bachelor pad with an open entertaining area and large master bedroom. The views of this exclusive Bonnie Knowles Country Club and golf course are breathtaking. Hurry, this home won't last. Are there any fair housing violations? About everything there is against fair housing. What should the ad have said? Let's look at slide 59. It should have said, this large home offers plenty of open entertaining space. Enjoy the views from your back deck or upper master bedroom patio. This home has many amenities and upgrades. Hurry, it won't last. Remember, advertise the property, not who should live there. That's a good statement. That's a good statement. And bottom line of fair housing, of course, treat everybody the same. Let's go to the complaint process. If there's been a violation in your estimation, anyone claiming discrimination has the following time periods from the date of the incident to file a complaint. You actually have 1 year to file with an administrative agency like HUD or the Colorado Civil Rights Division, or 2 years to take it to U.S. District Court, to federal court. So 1 year to go to HUD or Civil Rights, or 2 years to go to the U.S. District Court. And one of the things that they don't mention here, only the aggrieved person can file a complaint. You see an action happening that you think is something wrong, you cannot file it. Only the aggrieved person can. Let's continue here on slide 61. HUD and or the CCRD. Okay, that's the Colorado Civil Rights Division, of course. First, investigate the housing complaint and determine whether there are any proof of discrimination or violations of fair housing laws. The case investigator makes a recommended finding of probable cause or no probable cause. The director of the particular agency signs off or disagrees and issues the final determination. Even if the agency investigating the complaint makes a determination of no probable cause, the charging party, the complainant, may still file a private lawsuit. Kind of reminds you of OJ, when he went after the civil, it was a civil thing, they caught him even though he was found innocent. And new regulations, community association manager, this is what's happening big time right now. And it's creating quite a ripple through our industry, because if you're managing, we'll talk about individuals, you have to have a separate license now if you're a community association manager. You have to have disclosure of the Owners Association management fees and his Owners Association membership directory. Let's go to slide 63 or 62 again. Continuing. Integrated mortgage disclosures and the 2014 Sunrise Review for home inspectors. Home inspectors have to be licensed by the end of the year. We'll be talking about that in just a second. Let's talk about this Community Association Manager Licensing Program. Slide 63. Effective July 1st, 2015, mandatory Community Association Manager Licensing Program. The license required if meeting the statutory duties, regulated by the Division of Real Estate and Community Association Manager Licensing Programs. Those requirements to be licensed community manager are, these are the people who have to be licensed. Any person, firm, partnership, LLC, association, or corporation that performs more than one of the community association management practices in consideration of compensation by fee, commission, salary, or anything else of value, or with the intention of receiving or collecting such compensation. And the Community Association Manager Licensing Program. Slide 65. Community association management practices are defined as, again, receiving, depositing, controlling, or dispersing funds of the common interest community, if you're working to deal with any money with the association, preparing budgets or preparing other financial documents, assisting in the creation and implementation of a reserve program for the replacement of capital assets, or assisting in the provision of notice or conduct of meeting of board members or unit owners. And again, look at slides in the Community Association Manager Licensing Program, slide 66. Contracting for or coordinating maintenance of property and facilities of the common interest community, conducting property inspections, administrating applications for architectural review, and keeping records of violations of the governing documents of the common interest community, and performing other services relating to the day-to-day operation of the common interest community. Slide 67. The Community Association Manager Licensing Statute encompasses the licensure of professional managers that manage various types of common interest communities. Why is it called a common interest community? Because part of the land or buildings or whatever are part of the common interest that everybody's involved with in that community, including but not limited to residential, mixed use, commercial, timeshares, and hotel communities. There are exemptions under the law that do not require a license. Let's go to slide 68. All managers meeting these requirements and any real estate brokerage engaged in any activities requiring a CAM license will need to complete the CAM education requirements and pass the CAM state license exam and make application with the director, submit fingerprints to the Colorado Bureau of Investigation, comply with additional insurance requirements, and meet the requirements for renewing, maintaining the CAM license, including continuing education requirements. And the real estate, slide 69. And the reason, and the CBI, talking about the fingerprint requirements, the Colorado Bureau of Investigation destroys all the fingerprints after 6 months. So every time it's renewed, it has to have new fingerprints again. And that's how we're doing now with real estate brokers, mortgage brokers, everybody. Just have to submit a new set of fingerprints every 3 years or whenever your license is up. Slide 69. Real estate firms or brokers managing an homeowner association, again, must have a CAM licensed designated manager similar to an employing broker who is responsible for all the association management and all CAM licensees in the firm. And the DM is personally responsible for handling all common interest community funds, may require additional escrow accounts and insurance policies, and disclosure of the Owners Association management fees. Slide 7. This statute, disclosure of fees and charges to an Owners Association by a community association manager or management company, and the manager must disclose to, again, the Owners Association Board all fees charged during contract negotiations and annually. Must be disclosed as part of the written management contract. and must disclose any other remuneration it receives that is in any way connected to its relationship with the Owners Association. And this is effective January 1st, 2015. It's in effect now. And the Owners Association membership directory on page 71. The HOA membership directory publication bill. Just in hesitation here for just a moment, to get this licensing, we do offer it here at American Real Estate College, this licensing for these homeowners associations, this designation, the CAM designation. So please give us a call. We do it on DVD. We also have it live. So give us a call. We're glad to accommodate you in these. And continuing, slide 71. It allows an owners association to include owners and resident telephone number and email addresses in a membership directory, provided that written consent is first obtained from the owner or resident to publish. And consent can also be withdrawn by the owner or resident. And effective August 6th, last August 2014, the integrated mortgage disclosures, slide 72, the Consumer Financial Protection Bureau integrated mortgage disclosure rule will be effective August 1st, 2015. Lenders are prohibited from using new disclosures prior to the effective date. These lenders and title companies are getting a continual flow of different forms they have to fill out, things they have to do. The days of the 2-week close are pretty much a thing of the past, unless it's a cash deal. If you want to do a deal in 30 days, you're pressing it now. Figure 45 days. Word to the wise. Give 45 days to close your deals. You make it any sooner than that, sometimes you have to. But there's no reason to keep it less than 45 if there's any way you can possibly wait that long.
This is due mostly to the delays being caused with the mortgage brokers.
Because, no, it's not the delays being caused by the mortgage brokers.
Well, I mean, with the
Is
state.
yes, the delays being caused by all the additional paperwork.
Right, but I mean,
Yeah.
it falls that it affects them.
It's not only lenders, but title people too. Yeah, they're just, and we too, we're getting hit. Real estate brokers, but we're not getting hit anywhere near as much as these poor lenders. Wow, they are just having to jump through so many hoops now.
Now, are these just specifically with the state of Colorado, or is this affecting the nation as far as all these
Great.
state regulations?
Great question. Is this just Colorado or the nation? Well, let's continue. And it is national. It's not just Colorado. So let's look at 72 here. Slide 72. The Consumer Financial Protection Bureau Integrated Mortgage Disclosure Rule will be effective August 1st, 2015. Lenders are prohibited from using new disclosures prior to the effective date. New loan applications initiated after August 2015 must utilize the new disclosures. And these disclosures, slide 73, the Integrated Mortgage Disclosures Rule consolidates 4 existing disclosures required under Truth in Lending, good old TILA, you remember that from before you got your license? And the Real Estate Settlement Procedures Act, good old RESPA, for transactions secured by real estate into 2 forms. Now, remember there was the RESPA form, which was called what? The Good Faith Estimate. You had to have 3 days after loan app, as well as the Truth in Lending requirement, 3 days after loan app. Now, the new loan estimate form integrates and replaces the existing Good Faith Estimate, the RESPA Good Faith Estimate, and the initial Truth in Lending forms. The new closing disclosure form integrates and replaces the existing HUD-1 with the final Truth in Lending forms. Integrated mortgage disclosures. The new disclosures, slide 74 here, the new disclosures apply to lenders for most loans secured by real property, with the addition of some loans that were previously covered under TILA, but not RESPA, which are like construction-only loans. Like construction was not initially covered underneath that. Loans on properties of 25 acres or more, vacant land if a home will be constructed within 2 years, and integrated mortgage disclosures. Slide 75 here. The new lending disclosures do not apply to reverse mortgages, Existing good faith estimates and HUD ones will be used on these loans. Mortgages secured by a mobile home or a dwelling not attached to real property. And of course, a mobile home is considered personal property unless the land goes with it. And certain no interest loans, second loans. Remember, second mortgages are always interest only. So are HELOCs, home equity lines of credit, are made for down payment or home buyers assistance, property renovation, energy efficiency, foreclosure avoidance, or prevention programs. And a person who makes 5 or fewer mortgages in a calendar year. These still don't apply, 5 or less. And integrated mortgage disclosures. 76, lender loan estimate basic disclosure requirements. Required to provide a loan estimate within 3 business days of a loan application. If loan is locked after initial loan estimate is provided, a new loan estimate must be provided the same day as the lock. Revised loan estimates require a 4-day waiting period. The borrower must receive the new disclosure at least 4 days before closing. And integrated mortgage disclosures. So this integrated loan estimate, it has to be 4 days before closing, so that you cannot close within those 4 days.
It's not going to make it really tough on them.
Oh, that's going to make it real. But this is good. This is good. These lenders, a lot of lenders, not a lot of lenders, a few lenders now guarantee that you're going to have your figures 3 days before closing, and they guarantee it. Why shouldn't everybody be able to do that? And so again, how many times, I can't tell you how many times I'm sitting at the closing table and we don't have the final figures. The buyer's sitting there, doesn't even have a check because they don't know how much to bring. You know, it's time for these lenders to get on the ball with this, and now it's forcing them to do it. It's going to cause some concerns, and it's not going to be an easy transition for a lot of these lenders to do. So let's keep reading about this. Lender closing disclosure basic requirements must be received, what I just said, must be received by the consumer at least 3 business days before closing. Isn't that something? It's etched in stone now. They tried to do this in 2008, and the whole country laughed at them. Then they said they have to have all these figures 24 hours before closing, or you had to delay the closing 24 hours. They were still laughing at them. Well, now it's etched in stone. So let's continue here. It gets stronger even. Let's read this. Must be received at least 3 business days before closing. Must be given to each consumer who has the right of rescission if a rescindable transaction, such as a refinance. If you refinance with another lender, you have a 3-day right of rescission. Your second mortgages, your HELOCs, you also have a 3-day right of rescission. If a revised loan closing disclosure is issued, it may trigger a new 3-day waiting period. The instances where this might occur are the disclosed annual percentage rate becomes inaccurate, there are changes in the loan product, a prepayment penalty is added or amended. And on slide 78, it says, integrated mortgage disclosures. Real estate brokers should be aware these new rules may impact closing dates. Brokers should also be knowledgeable about the forms and the delivery dates required by law, since the lender must be in compliance in order to complete the loans. It is highly recommended that all brokers take an additional course on the new integrated disclosures and these new integrated mortgage disclosures. First of all, let's say that you have a problem that hits on a Friday, you have to wait at least 4 business days before you can close that loan. So what if it's a 3-day weekend where Saturday is not considered a business day? It could be the following Thursday or Friday before you can close that loan. It could be a complete week delay if these aren't done. Like I say, there's going to be some bumps in the road on this. But we've got to be able to explain to our people that it's not us, it's the industry as a whole, it's federal regulations, and this for one purpose, and that's to protect the public, to protect the buyer. So they can get upset as they want to get. It's to their advantage to make sure that this is done correctly. So, let's go over to slide 79, I believe we are. Talks about the Consumer Finance Regulatory Implementation, TILA-RESPA. We have the, again, the CFPB's Guide to the Forms, Integrated Loan Disclosure Forms and Samples, their Compliance Guide, the Model Forms, Blank and Completed Samples, and the 2014 Sunrise Review for Home Inspectors. How are we doing with this? Any questions about this? You really don't have enough information here to even ask questions yet. Once you start working with these forms, then you can talk to your lenders about that, and they'll be able to explain them to you about what these forms are doing and what they're not doing to make sure that you're in compliance. Now, licensing home inspectors. This is interesting. By the end of the year, home inspectors have to be licensed. In the year 2000, I was on the board of directors of the Colorado Association of Mortgage Brokers when we had drafted the initial bill to get mortgage brokers licensed. And it was real interesting. One of the state senators came to us, and his wife had been jacked around by a mortgage broker. And he came to us and he said, "You guys leave the licensure industry or we'll do it for you." But even at that, it took 8 years to get these mortgage brokers licensed. In 2000, when we first submitted, we went into the sunset review, and on July 1st, 2000, the home inspectors asked if they could piggyback with us. And we said, "You bet. Let's get them licensed. Of all the people who need to be licensed, it's home inspectors. Wow." You go out and buy a ladder and a flashlight, and all of a sudden you're a home inspector. You know, there are these phantoms going out there killing our deals because they think the more they find wrong with the property, the more justified their assignment is. And they're just killing us out there so much. You find a good inspector, they're worth their weight in gold. And what happened is in the year 2000, the state said, "We're not even going to consider licensing home inspectors because the only complaints we're getting on home inspectors are not from consumers, they're from real estate brokers." I thought we were consumers. I guess we're not. So anyway, that was the year 2000. So we're looking at 15 years ago. Finally, it happened. We're going to get these home inspectors licensed. Wow. What a step in the right direction. So
When is that, Jim?
January 1st of 2016 is when it's going to be.
Are you going to teach that class?
Am I going to teach it? You better believe it. Oh yeah, you better believe it. Yeah. I want to be very involved on that.
And mortgage brokers, when was that done?
The mortgage brokers, had to be licensed. Actually, we got them registered in 2006, and there were 10,500 mortgage brokers that got registered in the year 2006. We got them licensed in 2008. And in 2008, there were a little under 4,000 mortgage brokers that got licensed. 10,500 registered in 2006, less than 4,000 licensed 2 years later, which means in 2 years, 6,500 mortgage brokers disappeared in Colorado.
Wow, that's true.
Isn't that something?
Huge.
Of course, that's when everything collapsed.
Right.
You know, 6, 7, and 8.
Yeah.
And so that's what it is. Right now, I believe the number of mortgage brokers licensed out there are about 4,500, from what I understand. So I would assume there's probably that many inspectors that are going to be licensed also. Nobody knows how many inspectors are out there because there's no registering, there's no licensing. So it'll be interesting to see. But boy, do they need to be licensed and registered or whatever. You better believe it.
So did you
Yeah.
say the inspectors are you going to register them first so you can see what these numbers are?
Are we
Kinda
going to
like the
register them
mortgage-
first?
Like the mortgage brokers?
Are we going to register them first? Absolutely not. They're going to be licensed. You bet. Let's get them licensed.
You don't want to see what the numbers were before, huh?
No, and well, see, we had a conflict with Governor Owens when we got them registered, and Governor Owens didn't have the initial setup to get them licensed and everything, and he threw a party one time at his mansion. I won't go into details on tape now, but anyway, and it was a heck of a nice party we went to. A bunch of us did, and at that party, we kind of hit him up, and we said, you know, Gov, what we want to do, we didn't call him Gov. We said, Mr. Governor, Mr. Owens, we said, we're with the, Colorado Association of Mortgage Brokers. He said, hey guys, he almost put up a cross sign with us, He said, I have no money to start. I can't endorse you guys. We said, would you at least register mortgage brokers? He said, I may be open to that as a halfway measure. Son of a gun, we held him to it, and we did it for 2006. We don't want to jump through that same hoop for inspector. Let's get them licensed and get them down the road. You betcha. Make sure we got these requirements in place. Long overdue. I think we're looking back 15
Yeah.
years.
Why even have them?
Have what?
If they're not licensed.
Well, the home inspectors, yeah, most of them, and that's not exaggeration, are worthless.
Well, yeah, I
They're
mean, if
less
I
than
can put on
worthless.
a badge and
Yeah.
say, I'll come in and inspect your home, but they don't know what they're doing.
They have no clue.
They don't build houses, they don't know anything about plumbing, electrical.
No, it's terrible, terrible,
Mhm.
terrible. Now we're gonna have some consistency in our industry. So we're gonna get homeowners licensed now. If you're in a homeowner association, we're getting inspectors licensed. I'm not for bigger government, but I'll tell you what,
The
we've all
inspectors
lost
should be
deals.
licensed.
We've all lost deals because of inspectors, and if you haven't, you're going to. And even once we get them licensed, there's still gonna be some clowns out there.
Why do we get the inspection so close to the closing date when it could kill the deal?
Oh, why do we get inspections close to the closing date? Not on my deals. I get that inspection done within 10 days
Mhm.
at the most. Because if a deal's going to fall apart, more times than not,
That's when
because of
it's
that
gonna be.
inspection. You want that inspection right away, guys. Heck yes. Now, you don't wait until you're closing.
Okay, I thought you waited.
Now,
till the-
appraisal you do, because the lender orders the appraisal, and that's the last thing to be ordered typically. Because all the other contingencies have to be met so that people don't get stuck with that cost. So, but the inspection, oh no, do that ASAP. All contingencies, and there's 7 different contingencies that are subject to the buyer's discretion, personal discretion. For any reason or no reason they get out of it. Until you get those satisfied, you don't have a deal. So let's continue talking about home inspectors here. I like it. Slide 80. Here we go. The Office of Policy Research and Regulatory Reform. Boy, that sounds official, doesn't it? Office of Policy Research and Regulation Reform released its Sunrise Report in October of 2014. Reports found instances of harm to the public is identified from the number of sources. The Arapahoe County Sheriff's Office, Office of the Attorney General Consumer Protection Section, Denver Boulder Better Business Bureau, Colorado State Electrical Board. Wow. Report recommends all home inspectors in Colorado to obtain a license prior to providing home inspection services. Slide 81. Sunrise application recommends a licensing program to provide licensed consumer protection. Program should have the following safeguards. Number 1, home inspectors should pass an examination, complete a finger-based criminal background check. You know, these inspectors are going in this home, every bedroom of the home and everything. No background check on these guys? Wow, we have to have it as real estate brokers. They don't? Isn't that something? And actually, appraisers didn't need it till last year. Isn't that something? Appraisers, again, going all through the house. Who knows who these guys are, really? Some of them. Obtain a license from the state of Colorado. Should be regulated by a 7-member home inspector board. Isn't that funny? Real estate commission, it's only a 5-member board. Appraisers, it's 7. And for mortgage brokers, it's only 5. But here we're going to have a 7-member board. And should complete continuing education training also. Now, just as a side note, should real estate brokers maybe get licensed as home inspectors? Why not? That's another income stream. Could be some side money for us. You know, you can't inspect the homes that you're doing your own deals on, but what the heck? You know, get your name out there.
When was it the appraisers had to get licensed? When was that?
When did the appraisers first get licensed? It was in January of 1991. So they've been licensed for
It's been quite a while.
24 years. Oh, yeah.
And the inspectors have to be licensed by 2016.
And the inspectors by January 1st, 2016. And this licensing for homeowners by July 1st, 2016. So all this stuff is coming, piling up on us, guys, but it's to protect the public. And again, having some oversight. And yes, appraisers again are licensed as of January 1st, 1991. It's kind of funny. In 1990, about January, Stuart Leach, who was putting it all together for the Division of Real Estate for appraisers, called me up. And he and I got to be not good friends, but pretty good associates. And he called me up one time and he asked me, he said, it was like January, a year before licensing came in, and he said, how many real estate appraisers are out there, do you think? And I said, shoot, your guess as good as mine. Nobody knows. There was no registering or licensing. And Stuart Leach said, I'm thinking 1,800. I said, good a number as any. And he said, what I'm going to do is number the licenses back from 1,800 backwards. And a month later, in February of 1990, I got my license, almost a year before I had to have one. And my license number was 00001799. So I was the first appraiser licensed in Colorado. You know, I don't have
That's pretty cool.
I don't have a lot of claim to fame. I'll take that little teeny one there.
That's a
You
nice
know?
one.
So-
First appraising license.
Yeah. So anyway, let's slide number 82 here. We have the response to the Colorado Housing Council, and there's that slide 81 talks. There's that website you can go to get more information about what's going on out there. We have the slide 82. Colorado Housing Connects, the Consumer Financial Protection Bureau, the Attorney General's Office, the Denver Metro Fair Housing Center, Colorado Housing Connects. The Colorado Housing Connects project priorities are number 1, slide 83 here, to provide access to rental and tenant landlord counseling, provide access to home ownership education and foreclosure prevention counseling, and address aging housing stock as it relates to minor repair, rehab, and accessibility modifications. Number 4, identification of potential housing discrimination. Number 5, assist senior and special needs populations. And 6, of course, seniors and special needs. Seniors, 11,000 individuals are turning 62 every day, turning 65 every day, and starting in 2016, turning 70 every day. And they have a lot of power behind them, the baby boomers, of course. And with that much power, we're going to see a lot of senior assistance programs happening. Number 6, triage residents' housing needs. Provide appropriate referrals and education information. And again, Colorado Housing Connects, slide 84, connects residents to a community of housing resources through a centralized portal. And triages residents' housing needs.
What does
And
triage mean? Expedite?
A triage, that's a medical term. I think it's more of a provision issue as far as assistance care. And I may be off a little bit more on that. If there's a nurse who could explain a little bit. Anybody nurse here? I guess not. I'm not.
Triage from the MASH units where it was kind of a.
Oh, the
Emergency.
triage from MASH. That's right. Yeah, the
it's an
triage.
emergency.
Kind of like it's an analyzation, right? Pretty much going to triage thing.
It's for all the welfare babies so that they can,
The welfare babies. Okay.
in case they find themselves homeless.
That could be. Okay. And again, triage residents' housing needs, provide appropriate referrals, education information. Colorado Housing connects residents to community of housing resources through a centralized portal, and provide an efficient one-stop housing referral point. Eliminates referral loop and circle of callbacks. Provides a central outcomes-based reporting platform. This could be a good thing for licensed brokers to get involved in. A lot of these people have homes they have to sell, et cetera, et cetera. That might be the best thing you get out of this today. That could be another income stream. Think about that. Identifies housing resource voids and mobilizes community stakeholders to address issues. And then Consumer Finance Protection Bureau, go to slide 85, submit a complaint. Loans, mortgage, student loans, vehicle loan, or lease, payday loans or other consumer loan, product and services, bank account or service, credit card or prepaid card, credit reporting, debt collection, money transfers or virtual currency or other financial service. And again, the Attorney General's office is also an avenue. The Attorney General's office is more than just for, it's mainly for complaints. Very few end up that far along. Usually you have a mediation process where complaints are handled outside of having to go that far. And file a consumer complaint. The Office of Attorney General's Consumer Protection Section is charged in protecting Colorado consumers from deceptive trade practices, antitrust infringement, and a wide range of other violations of the Colorado Consumer Protection Act. The Attorney General's office works with the Better Business Bureau and other agencies to investigate consumer complaints against businesses, creditors, and collection agencies within Colorado. Slide 87 talks about the Denver Metro Fair Housing Center. The Denver Metro Fair Housing Center is the voice of fair housing in Metro Denver. And it works to eliminate housing discrimination and to promote housing choice for all people through education, advocacy, and enforcement of fair housing laws. If you feel you have been a victim of housing discrimination or have observed something you want to report, please get in touch to file a complaint. And again, the Denver Metro Fair Housing Center. And how do we file a complaint? We're on slide 88 here. The Fair Housing Center is available to assist in the filing of housing discrimination complaints and can file complaints based on its own investigation. The phone number is there, 720-279-4291, or visit that website right there. Individuals may file an administrative complaint with HUD or with the Colorado Civil Rights Division within 1 year of the alleged discriminatory act. And individuals may file in state or U.S. District Court within 2 years of the alleged discriminatory act. Kind of redundant. And then the division news, slide 89 here. There's the new e-license licensing platform, the 2015 Colorado Real Estate Manual, and that is available now. And we have slide 90, the e-license licensing platform. And this is the expected releases later on this year in 2015. We'll move application processing online with internal review, transfer upgrades, new license applications, etc. And we'll provide licensee with full control over license record via online portal. And the e-license licensing platform continuing. And this is slide 91, will allow licensee more flexibility in transferring, modifying contact information, and changing license status. It will require creation of new accounts to access, and the division will be giving how-to instructions prior to its launch. Slide 92 here talks about 2015, the Real Estate Manual. The manual is not only a beneficial resource for new licensees, but for existing real estate brokers, appraisers, and other real estate professionals. It provides current relevant statutes and requirements for practicing in Colorado. The ebook download benefit of a searchable digital manual for quick access to new information, statutes, rules, and position statements. Let's take a minute on this. You can take the real estate manual and download it into an ebook where you can key in just one word and then find where every place that word is in that real estate manual. It is very usable, very cool to do, because actually that real estate manual is not well indexed at all on its own merit. But turning it into an e-book changes everything. So if you do get the new manual, the information on how to turn that into an e-book is in that white sheet of paper that's beneath the plastic that you're tearing off that book. And so you might have to give them a call or give one of the young guys who's computer geek in there to set up that ebook for you. That's what I had to do. but they'll get that set up for you, then you have it. Then you have it.
Is there a phone number in the book?
It's actually, the phone number in the book, no, it's actually in that white sheet of paper
Okay.
that I mentioned. It's got everything on there that you need. You might have to call up LexisNexis, that's the one who does these books now. And they're out of, they're back east, New York, essentially. And then feedback requested. The Commission's Education Force wants input from you. Your feedback is incorporated into future versions of the course and used as a guide to help improve instruction of the course. If you don't like the course itself, tell the Real Estate Commission that. If you don't like the way I'm teaching it, come tell me. They don't care how I teach it, as long as this information is covered. But if this information was not important to you or relevant, you can contact them and tell them you want more information about this next year. And they will listen. They will listen. Like a lot of this property management this year. Licensing home inspectors, stuff like that. Not a whole ton hitting real estate brokers in a lot of ways. A lot of times it's all real estate brokers. So again, and take the survey, there's the website for the survey, etc. Now, the next page is the 10-question test, and those of you who are looking at this on DVD, take this test now and send it in. You can fax it over to us, and our fax number is 303-426-6696, 303-426-6696, 303-426-6696. You can scan it to us, whatever, at AmericanRealEstateCollege.com, AmericanRealEstateCollege.com. But do get this test. It's a 10-question test. And get that over to us. Those of you who are taking it live, I'll give you the next 15 minutes to do it, then we'll come back and go over these questions one by one. I will not do that on the DVD. I'm not allowed to. We have to grade those tests separately. And this is the end of the 4-hour mandatory course. And once you get your test graded and passed, we will get you out a certificate of completion. Thank you very, very much for coming to the meeting today, to the class. And if you have any questions, please contact us. My personal cell phone, if you need to get a hold of me personally, again, my name is Jim McCloskey. Jim McCloskey, 303-913-1984. 303-913-1984. Have a fantastic rest of the day.